Good afternoon, everybody. Thank you for joining us this afternoon. I know the sun is shining, so we're very grateful for your time this afternoon. As you know, you've joined the immigration team's webinar on COVID-19 measures that have been brought in immigration. My name is Sarah Pinder, and I'll be presenting along with my colleague Samina Iqbal. As you may have seen, Kezia Tobin, our colleague, was due to present this webinar at the start, but she had a prior commitment, so she was not able to do so instead. So I'm sorry about that, but hopefully we'll be able to do a good job standing in her place. As we all know, these are really extraordinary times. It's really unprecedented for everyone. So us lawyers, but also tribunals, clients, all having to face these challenges and keep abreast of really daily and certainly weekly changes and new developments. In this webinar, we are trying to bring together for you the developments and the new guidances that have been brought in. Both by the Home Office, but also the courts, so on both fronts, as a direct result of the COVID-19 pandemic and the lockdown measures that were introduced in March. No doubt many of you, if not all, may be familiar with most or all of the changes and the challenges, but we hope that this webinar will be a bit of a go-to guide, a checklist, if you like, as this period has obviously given us a lot of challenges to face, and hopefully it will be easier for you to navigate after. In the webinar, we will cover first the steps that applicants, that persons who are here already with leave to remain may have to take in order to cover themselves. So if their leave is due to expire very soon, or during at a time where they are not able to travel back home and they're not able to leave the UK. We'll also look at special policies and exemptions that have been brought in for some categories of workers, and also, as mentioned, policies and procedures that have been brought in by the courts and the tribunal service for lodging appeals. So that's statutory appeals, very briefly for bail, and also judicial review claims in immigration. So that's what we'll be covering. Just a few matters of housekeeping, so to speak, before we make a proper start. There will be a Q&A session at the end. So we hope to make enough time, to leave enough time for that. And also at the end of the webinar, before you leave, there will be a short poll for you to answer if you can, just to gauge your interest in the webinar, how your experience was, and if there are any other topics that you would like to see covered by the immigration team. Please don't hesitate to contact Chambers or either myself and Samina so that we can have a look at that and see what we can do. And lastly, the slides that you're seeing here on the screen and the recording of the webinar when this is ready will be made available on our website for downloading, so you can come back to that. Recommend it to colleagues who may have missed the slot if you thought it was useful, and those will be ready on the website really no later than Monday of next week, so bear with us, perhaps not ready for tomorrow, but certainly by Monday. And lastly, on the slides, they do include hyperlinks, so you won't be able to access those live at the moment, as Samina is showing you here on the slightly grayer font and underlined. That is a live hyperlink, and that will be kept in the slides that you can download. So it does short circuit, it does give you shortcuts to all of the guidance that we refer to within the slides. So that's it by way of introduction, and we'll move straight into in-country applications. In terms of in-country applications, one major development was obviously the procedures that were brought in by the Home Office in terms of the automatic extensions for persons who cannot leave the UK due to lockdown, due to having to self-isolate, due to procedures in their own country that are not perhaps admitting anybody from certain countries like the UK at present. So we're in our second wave, I think, of extensions that have been brought in an automatic manner. And so the latest one was announced very recently on the 22nd of May with the Secretary of State Priti Patel making an announcement to that effect, that those with temporary leave would be extended automatically until the 31st of May. The extensions of leave that were until the 31st of May 2020 are automatically extended now until the 21st of July 2020. So it applies to really everybody who has a temporary form of leave, so visa holders, short-term residents, and so on. The process that had been in place was emailing the centre, and now that has been replaced by a different procedure. So we see that in the slide that you've got up now. The updated guidance is there in the first sentence of the slide. And you now have to fill out an online form in order to essentially record your position, to record your details and the need for such an automatic extension of stay. So again, the online form is hyperlinked, so you'll be able to access it there. There was a bit of controversy first in the manner of the announcement because it doesn't seem to be anywhere on the gov.uk website for now. That may have changed since the 22nd of May, but it was done as a form of sort of press release, press statement, and a separate announcement. So there was a bit of criticism on that front, as that is not entirely accessible to everybody. But also the other controversy, perhaps to the more astute legal minds amongst us, is the fact that this procedure to automatically extend a person's stay in this manner doesn't, strictly speaking, extend a person's leave under Section 3C of the Immigration Act 1971. So we don't have the time to go into that in detail because it's very technical in terms of how the application is made, certain steps need to be taken and so forth. But that is what is being highlighted, that strictly speaking, it doesn't extend the Section 3C leave. Now, the Home Office have obviously announced that no enforcement measures would be taken during this time. And obviously there'll be a form of record with the online form being submitted, but we would certainly advise everybody, any clients taking these steps to make sure that records are kept. So obviously if they're represented, that would be through yourselves as practitioners, but if it's on a direct access basis, for example, with barristers, you would want to keep a record for themselves as well. So I think it's important to stress that. You also have the ILPA's guidance, which is at the bottom of that slide. So both for the visa holder and for sponsors, so employing persons, employers who have persons who are in this category. It is slightly, I wouldn't say out of date, because a lot of it is still very relevant, but you'll see the publication date of the 9th of April. So access that with a bit of caution, and I would always advise look at the Gov.uk websites in conjunction. So we'll look at the next slide now, just specifically in terms of visa, whilst we're on the topic of visa extensions, there is, as you will have seen in the media, a very big category that has benefited from a sort of automated procedure as well due to COVID. So the current climate with the pandemic has been reflected in the concessions made for NHS workers. Again, there's been several steps in the announcements as obviously reactions have taken place to the initial announcement. So at the very beginning, at the end of March, the announcement was made in the context of NHS workers. There was some confusion perhaps as to whether that was only tier 2 workers or perhaps other visa holders, other working categories that may be working for the NHS but not necessarily under the sponsorship scheme in tier 2. But that was clarified. So it's definitely inclusive of other tiers within the points-based system, but there may be different categories outside of the points-based system as well, where such persons are working in those categories. And so those persons with leave expiring by the 1st of October 2020 would benefit from a 1-year extension, and that is again automatic. There's no need for an application, there's no need for a fee, and that would also, if the visa holder in that post is eligible, it would very likely cover their family members, their dependents as well, who are here. So it's again a family unit. If the worker is eligible, the others should follow. Following again a bit of reaction from the public, from politicians and so forth, from the various stakeholders, that concession has been extended further and is now termed as NHS and frontline health workers. So it becomes a bit more complicated with the lists of professions, of occupations that are included, but essentially, again, that is obviously a positive development in that it includes a lot more categories of persons. For instance, persons employed by an independent healthcare provider would also benefit as well. You've got the link there towards the bottom half of the slide to access the categories of workers who are qualified. Essentially, it's really all very medical based. You have also dentists and other branches, if you like, of the medical profession. Most notably, the ones that I noted that I wouldn't have necessarily thought of as being included are psychologists, social workers, speech and language therapists, and therapy professionals. Again, that is useful to know. Arguably, it doesn't go far enough because obviously there are many, many support workers, many different types of organisations and workers who will be supporting the NHS during this time. But obviously that's a start, and that's something to be aware of going forward. The process is seems to again be very straightforward, an emphasis on really very little proactive steps to be taken by the individuals concerned. So that would, the employee just has to wait to be contacted. It's very much liaising between the employer concerned and the Home Office, and then when the time comes of submitting the biometric documents, that then involves the employee themselves. A very last brief update in terms of NHS workers. As you will have heard, I think it was only last week, the immigration health surcharge was abolished for NHS workers. And I say probably abolished a bit, that's a bit of an overstatement, because we don't know really the details in terms of the scheme. We don't know if it's going to be time limited. We don't know how far that is going to really be implemented. But again, it's a start, and then it may provide grounds to look at obviously making headway on the immigration health surcharge in a different, for different persons, different other workers perhaps. So I'll leave you now to Samina, who's going to look at the position for entry clearance applications in a bit more detail.
Thank you, Sarah. Yes, just looking at what happens, we've looked at in country, but what happens to those who want to come into the United Kingdom at the moment. Well, last week, Priti Patel announced that a 14-day quarantine regime was going to be introduced as of the 8th of June 2020. It would apply to all international passengers, both residents and visitors in the United Kingdom. So what was going to happen in relation to the process for those travellers? Well, we're going to look at completing an online locator form, providing their contact details, travel itinerary and accommodation details. The travellers were going to face spot checks at the UK borders on arrival to ensure that they had completed the form and provided the required details if they had not done so. And travellers were going to be required to self-isolate at an address, a specified address that they'd given for 14 days after arrival. They would also face additional spot checks by police at their specified address to ensure that they were compliant with their self-isolation. Well, what if they weren't, and what if they didn't want to comply with these conditions? Well, there are penalties that they would face. Firstly, an initial, anyone who's not a British citizen would face, could face refusal to be allowed to enter the United Kingdom. They would also look at penalties up to £1,000, and that was introduced as a fixed penalty for England and Wales only. Outside of England and Wales, there are other enforcement sanctions being considered, and certainly individuals could, who were refusing to self-isolate, could also face potential prosecution and unlimited fines. it seems to have come a little bit too late compared to our EU counterparts, and it may well be because we're no longer part of Europe, but certainly the government have reasoned that it's important in essentially safeguarding the risk from a second wave. And we'll see that there are certain exemptions, rightfully so. These exemptions include medical professionals who are travelling to help with the fight against coronavirus, anyone who's moving within the common travel area, covering Ireland and the Channel Islands, also seasonal agricultural workers who will certainly be coming to a certain property and self-isolating at that property. So it's worth looking at the links. If you have any individuals who are seeking to come to the United Kingdom, we've given you a link there which is worth considering in relation to any advice that you might want to give. I've got here other issues that you need to be aware of in relation to entry clearance applications and simply travel from outside of the United Kingdom, and other issues which might be important in the current climate. Well, we've seen the fee waiver policy, the challenge to the Home Office fee waiver policy. It involved a family who were destitute, and a challenge to them being able to the financial constraints that they were facing. And we'll see that this will continue with, unfortunately, many of our clients in the current climate who may have lost their jobs or who may have been furloughed, so don't have the finances and may want to take advantage of this fee waiver. So unfortunately, although the challenge was successful, at present, what we're going to be looking at is that the policy remains in place until the onward appeal has been considered, because permission has been granted. So I think this is something that Sangeeta and Ron will probably look at in a bit more detail to give you some more information about it. Looking at the unfortunate situation of separated families, we can see that individuals who have, that there's a very real threat given, as I already mentioned, the lack of income for certain individuals, that they can't any longer meet the minimum income requirement. So there are calls for this in particular to be reviewed, and we're going to have to watch this space to see what happens with this for people who want to enter the United Kingdom in whatever category, as a spouse, for indefinite leave to remain, or in country as well. You also have the no recourse to public funds, the High Court judgment, which was recently, the issue was recently litigated, and you have the question put to Boris Johnson, I think it was yesterday, in relation to individuals who are facing a situation where they are on the 10-year route, not allowed recourse to public funds, and unable to access universal credit. So it's something that he's said that needs to be looked at quite soon, and certainly in light of the no recourse to public funds litigation that is ongoing in the High Court judgment. It's something which we hope to see some development on. So again, keep your eye on this. In relation to entry clearance applications, which are in limbo, there is some limited guidance which everyone will be happy to be able to access. And some of the visa application centres are currently resuming services. So it's worth checking what's happening with those applications or those visa centres. But you also have Sheffield, who are managing a lot of the entry clearance applications, and certainly it's worth, there's no reason why they shouldn't continue to make decisions in these applications. So it's worth checking if any of your clients have entry clearance applications outstanding to ensure that those are being processed or are being processed in some way, or continued process in some way. If there's also an issue that we are aware of in relation to entry clearance applications where they've been granted, but individuals have not travelled, they've been issued the 30-day vignettes, but they've now expired. Well, there's a simple, hopefully what we know is a simple process where you simply email this email address that we've highlighted here and ask for a replacement 30-day visa, and those are being granted quite quickly. So that's quite heartening to know. But as we said, there are many changing policies. There's a lot of adapting to the situation in order to ensure that people are not at a disadvantage. But we are seeing time and again that there is a lot of disadvantaged individuals in the migrant community. But hopefully, through these various policies and the guidances and the questions continue to be asked, there will be changes, even though, and albeit they're slow. I'm just going to hand over to Sarah to talk a little bit about the appeal system. We're all quite familiar with what's been going on, keeping in regular touch with our clients and receiving these directions on a daily basis. But Sarah will take you through that.
Thank you, Samina. This is where we start to really rush through the slides. So apologies if we're running over a bit and obviously skimming through a bit of the content. But you have the details there in the slides. In terms of the statutory appeals in the first tier, we just highlighted obviously a bail hearing in the first bullet point there. Is we obviously know it's not a statutory appeal, but we've highlighted it there because has been really the only type of hearing that's run quite consistently through since lockdown. So they started quite soon after obviously the initial impact of the lockdown and have been held, we believe, in each hearing centre in the IAC, and have been done so remotely, mainly we understand by telephone, so that is positive. The CMRs, in terms of the listings of CMRs of what we have termed here the legacy appeals, so those are all the appeals that had been due to be heard from the 23rd of March or thereabouts, that were adjourned off from essentially each of the hearing centres. They are now starting to come back for CMR hearings conducted remotely. So from last week, we've certainly started seeing some listings, and there are more coming in the next few weeks, but it does seem to be quite at a very progressive rate. I don't want to say slow, but really quite tentative. The COVID directions that Samina has mentioned, so at the same time as a lot of appeals being adjourned off, the COVID directions were issued. They are essentially fairly generic directions, very similar to the digital reform that was being rolled out. What we wish to highlight in respect of these are just the difficulties really that we've experienced now that we've been in these procedures for a few weeks. You have those under the difficulties subheading. First, there seems to be, now that we're a few weeks in, or certainly a few weeks in of the CMRs coming along, are COVID directions and hearing centre specific directions being issued off the back of CMRs being listed. So some cases have had two sets of directions that might conflict with each other and cause confusion at our end in terms of which we should be prioritising and so forth. We would again suggest the most engagement is obviously the best way to do it. If you're unsure, contact the hearing centre. Make sure that you obviously are complying as much as possible. The funding difficulties in relation to appeal appellant skeleton arguments, so appeal skeleton arguments that are being front-loaded in the appeal process. So for legal aid cases that are out of scope, that is a funding difficulty with legal aid essentially not providing the remuneration for that, and we've just referred you to the Chamber's policy on that front, but also in obviously the vast majority of cases that are privately funded, with a lot of immigration cases not being in scope of legal aid, and that front loads the cost for appellants. And lastly, really a bit of skepticism perhaps, but we haven't really seen much engagement on the part of the respondents on the Home Office. The rationale to these directions, to list for CMRs, to direct for appeal skeleton arguments, is to have the respondent review decisions, to be much more proactive in that sense. And we haven't really seen that to date, and also a difficult level of engagement as well in relation to bundles, respondents' bundles not being received and so forth. So there's teething difficulties obviously, but it may be some time until we come back to a new normal when it comes to hearings. Face-to-face hearings, just a highlight again from our perspective, we haven't heard anything to indicate that face-to-face hearings are going to be happening anytime soon. Obviously the announcements to come from the government from this week or 1st of June will perhaps impact on that, but it's certainly I think a system that will be with us for a while. The next slide will be bail hearings. Samina will flag up just a few aspects of that for you to be aware of.
I do want to whiz through that. Thank you, Sarah, really quickly. You've already heard, if anyone was attending last week, a webinar with our head of chambers and Pierre, which covered this issue of unlawful detention claims applications in a lot of detail. We just wanted to highlight some of the very prominent changes due to COVID. We saw a high level of grants in the tribunals, and there was a controversial exchange between the Home Office and the first tier tribunal president, Mr. Clements, and we've highlighted the letter there for you. It's worth reading if you haven't already seen it, very interesting. But he gave his reasons and highlighted the reasons essentially why bail was being favoured in light of their criticism that there was too many bails being granted. But essentially removals are not imminent, and that's because of restricted international travel. It's as simple as that. We have set out for you 2 hyperlinks there on travel advice at present and foreign travel advice, and it simply says do not travel unless essential, and that kind of corresponds to removal not being imminent. But also in light of lockdown, there was lower risk of reoffending, individuals who would be shielding because of health considerations, and a high police visibility in relation to the lockdown provisions themselves. So these were all persuasive in terms of the tribunal, and certainly what we've heard back from BID, that in relation to 68 of the applications they made during that lockdown, 65 applications were granted, so completely consistent. Innovation here by the first tier tribunal in relation to bail is the minded to grant procedure. It's something that the Home Office weren't engaging with, a complaint made by the President, and if you read his letter, you'll see that. But he also highlighted that accommodation and licence issues was simply not a matter for the tribunal to consider. It's a catch-22 situation. We were looking at bail in principle previously, but he now highlights and underlines the fact that this is an issue for probation and the Home Office and wouldn't be looked at with reference to reasons for not granting bail. And as you may all be aware from your own clients, their individuals who are granted bail don't have to report because it's suspended up until the 17th of March. And certainly until lockdowns eased or lockdown ends, there won't be any easing, there won't be a need for individuals to report, and they'll be informed of that. I just again want to whiz through 2 other aspects, and that's in relation to the upper tribunal hearings at the upper tribunal. Given you a lot of information here, as Sarah's already mentioned, in the first tier tribunal, you're seeing a lot of directions being issued, same thing in upper tribunal for stat appeals. You also see for immigration judicial review that you can now lodge urgent or non-urgent judicial reviews via email, and we've given you the email address there for the ease of reference. Just be aware, I think, and it's important to be aware that we need, in relation to all bundles and attachments, we need to ensure that we stick to the limits and so that they don't exceed the size because they'd simply reject it, and then we'll be left with complaints of no consideration of the documents that we'd sent in. There's a slide here about administrative courts and the way in which they're running. I'm not going to take you through that, but the links are there for purposes of information. If you do have any cases that need to be lodged in the administrative court. And that brings us to the end of our webinar. We just want to highlight a couple of matters, general tips, because what we know is that it's still a very fluid climate. It's simply important for all of us to stay updated. We're certainly trying to ensure that you are updated via our newsletters, our mail shop, and all the announcements that are being made and what they mean. So it's important to keep in touch in relation to that, and to ensure that you're reviewing your client base so that you can keep your clients informed in turn about the policies, because it's overwhelming for them. It takes us time to understand it, let alone clients who just want to know how what's going to happen and when they can start working and continue with their lives here in the United Kingdom. A tip that we would give you just going forward for the remote hearings is familiarise yourself with what particular tribunal, the mode of communication that they're using. We know that Skype and telephone hearings are taking place, Skype for Business. So adjust essentially the time estimate that you're going to give alongside, because we know from what we've seen that it's taking longer via these remote platforms to conduct a hearing and for everyone to be able to look at the same documents that are being posted. What we know and hot off the press is that the cloud video platform, and there's a link here to the gov.uk website, is now going to be rolled out to all courts and tribunals. Sarah and I have just had an hour's training in relation to this, and it's quite simple. It's a nice, you feel almost as if you're in the courtroom. You're able to share documents, PDFs and so on, and it's quite a useful tool to have. But many of you who are already using webinars, it shouldn't take you long to familiarise yourself with the way in which it works. And that does bring us, I think we're pushing to the end of our webinar, and we're hoping to take questions, and of course we will be launching a poll for you to undertake, and we will be contacting you with another email which contains all the slides, but it will be up on our website probably about Monday. Sarah, is there any pressing questions at the moment that we can answer in the next?
Yes. So I think we'll have about 5 minutes tops for questions. I do want to take one contribution really from Kevin Scott. You may see it on your screens through the Q&A, but absolutely right. Kevin picked up that the visa extensions that I mentioned at the start, the automatic extensions are not until the 21st of July, as we set out in the slides, but are until the 31st. And rightly said, also, it is all on the gov.uk website. So thank you very much for picking that up. And again, it's an example of how really on top of these changes we all need to be. So thank you. But otherwise, I think I will just perhaps take an anonymous question, but one in relation to a client who is an NHS worker, so who is a nurse, and has family who are on the 10-year route, the parental route. Sorry, sorry, I'm just reading the question. The NHS nurse is on the 10-year route as well, but has dependents and minors. And so the question is essentially whether there's any benefit to make use of the 1-year automatic extension in relation to the NHS worker, so the main visa holder, and then obviously bring the family in within that, or whether it is better to continue on the 10-year route. I think it's a difficult question to answer. It will very much depend on perhaps the client's priorities in terms of the finances, in terms of how soon the leave to remain under the 10-year route is expiring. And and obviously what is going to remain in terms of other announcements from the government. So it's really trying to have that balance and to weighing up all of those priorities. So I don't really have an answer. I don't know if Samina does, but I don't have an answer for that, because I think it will be very client-led, and whether there's any further announcements as to whether those automatic extensions are going to go further. But if finances are an issue, obviously it's a free application for this stage, but it's also very short term. So I would probably hedge towards continuing under the route, and then it's sort of less change, less upheaval to deal with later. But that would be my assessment initially.
And I think just to add to that, we don't, as you know, to 3C leave, whether or not for NHS workers that would affect their 3C leave. One would hope it doesn't, but I haven't seen anything either way. So it's a bit ambiguous at the moment. Just taking probably another.
Then the next.
Go on, Sarah.
Sorry, no, I was going to highlight it for you, Samina, but one of the next questions I thought might be useful to cover, because we won't be able to cover all of them, is if an EA sponsor is self-employed but needs to access some of the concessions that have obviously been made on an income level, so accessing universal credit, for example, accessing those public funds, the question is whether the family who are dependent on them, so the third country family members who are not, who haven't got their status resolved, so they're still awaiting to have their treaty rights recognised under EEA law, whether the accessing of benefits would impact on that. And I think that's quite a good one, because I think a lot of EEA sponsors would be worried about that.
Yeah. I mean, that's a difficult one. I mean, when we look at the different categories for EA individuals, you also have the category of job seeker if they're temporarily looking for employment. And I don't know if someone loses their job and they're having to apply for universal credit. I mean, I think the arguments are there that they continue or remain a qualified person as long as they can fulfill the criteria. So I think that's something that, again, you'd have to look at all the circumstances referenced to that particular individual. But certainly an interesting question.
I think we've got time for one more. I've picked two out of the lot, so Samina, if you want to. And I do apologise, we won't be able to cover everybody's, but please do get in touch as well later.
Sorry, Sarah, did you say you'd picked another question?
No, go ahead if you want to.
Yeah, yeah. So I've just seen another in relation to the 30-day visa replacements for entry clearance applications. Does the same apply to EA family permits for those who did not manage to entry on time due to COVID? I think that it's likely the arguments are there. If they say it doesn't, there's certainly a very good argument for it being applicable to EA family permits as well. I don't see why it shouldn't apply, and certainly something that you can take up on challenge, and certainly a simple PAP should be able to resolve that issue. And just one last question, we've had something about a Home Office from Anna Green. We said all Home Office emails are not being replied. Who do we contact about outstanding entry clearance applications? And that you've tried to contact the visa, the Sheffield visa application. I think continue to contact those email addresses. We'll try and see whether we can find anything and post it up, or certainly send out a newsletter if you're signed up to our newsletters with any information that we do find. But it's going to be, I mean, I think it's just keeping up to date in terms of all the email addresses and all the various places, looking for the guidance on various places. But certainly we'll try and see whether we find anything to add to our next newsletter. So if you keep an eye out, and if you're not signed up to our newsletters, please pop an email to us, and we'll put you on our list so you receive those newsletters. And I think that brings us to the end of our webinar. So thank you everyone for attending. We have the poll up there, so we'll just wait a couple of seconds for everyone to complete it. Anyone who's still online to complete the poll before we end our broadcasting. Thank you.
Thank you both.